Okay. Good morning. Tēnā koutou katoa, e nā mana, e nā reo, e nā whenua o te ao no reira, tēnā koutou katoa. I greet you in te reo Māori, the indigenous language of the tangata whenua Māori people of New Zealand, where I was fortunate to flee from persecution and call home and find safety in Aotearoa, New Zealand, as a refugee. I acknowledge today that we are standing here on the ancestral Lenape homeland and recognize the long-standing significance of these traditional lands for Lenape nations past and present. So with that, good morning, everyone. My name is Rez Gardi, and I'm the co-managing director of Our Seat, Refugees Seeking Equal Access at the Table. I'm an international human rights lawyer admitted to the bar here in New York and in New Zealand. Thank you so much for joining us today for this discussion, the core paradox of international refugee law. Forced displacement represents the failure of modern state systems and invokes international legal structures to act. Without the protection of citizenship and intense vulnerability, the lives of those who are already most vulnerable is exacerbated. As a corrective to this, international refugee law is commonly understood as a framework for protecting the world's dejected and powerless. Equally and relatedly, international refugee law is understood as an exemplar of powerless. The global refugee regime is saddled with regular breaches of both its doctrine and its spirit, overlapping jurisdictions and a lack of accountability mechanism, rendering it powerless to protect many that are under its mandate. While other branches of international law have some sort of supervisory or reporting mechanism, international refugee law is entirely enforced by political accountability, which means that regularly states behave with impunity. This branch of law is a striking example of how these legal instruments can be simultaneously very powerful and seemingly powerless, depending on who is wielding them. So I'm excited to get right into this discussion with our expert panelists here. And so immediately to my right, we have Leah Zamor, Senior Research Fellow at the Zollberg Institute at the New School here in New York. And to the right of her is John Thon Majok, the Director of Refugee and Forced Displacement Initiative at the Woodrow Wilson International Center for Scholars. And then we have James Hathaway, the James E. and Sarah A. Deegan Professor of Law at the University of Michigan Law School and a visiting professor at the UCLA School of Law. And finally, but certainly not least, at the end, we have Emily Arnold Fernandez, the founder of Asylum Access and currently the managing editor of the Forced Migration Review, a publication of the Refugee Studies Center at the University of Oxford. So, as someone who's worked in the global refugee regime and having lived experience of forced displacement, I've seen firsthand how this branch of law is framed and contrastingly how it operates. And so in devising this session together, we wanted to consider both situations in which refugee law is fully applied and situations where it isn't, and how these both these types of situations can uncover this paradoxical tension within this framework of international law. So I want to get right into this conversation and firstly pose a question to all of our speakers here. The question is, how much injustice would remain with us in a world of perfect legality and compliance with refugee law? And I'll pass this off to Jim. Over to you first.
I love the question. And by the way, thank you all for choosing us and choosing refugees. I guess my short answer is, even if we had perfect compliance with international refugee law, there would still be massive injustice. And that's mainly for two reasons. The first is refugee law is predicated on what I call the accidents of geography. Wherever a refugee arrives is the one and only country that owes her anything. No one else has any responsibility but the state of arrival. And what that means is that 80% of the world's refugees are protected in the world's poorest countries. Rich countries are now spending more than, listen to this number, $20 billion a year to process the claims of the tiny number of refugees they receive. What they are spending on their 20% is 4 times what is available to meet the needs of the 80% in poor countries. Well, that's the first problem. And the second problem, which is just massive, is that there are presently 24 million refugees in the world, 2/3 of the world's total in protracted refugee situations, meaning they've been waiting on average 20 years for a solution, sitting behind barbed wire or in urban slums with no solution in sight. Of those 24 million people who've been waiting 20 years, only about 150,000, about 0.5%, get resettled in any given year. Well, international refugee law treats this as a voluntary act. There is no duty to resettle anybody. So a critical part of the protection journey, which is providing a home to people who can't safely go back to where they began within a reasonable number of years, is not even part of the regime. So the bottom line is a lot of injustice would remain because of the ridiculous accidents of geography theory for the attribution of responsibility, and even more would remain because resettlement is treated as a voluntary add-on rather than as a protection obligation.
Thanks, Jim. And I'll go to you, Emily, with the same question.
How much injustice would remain? I think one of the interesting things about this question is when we say international refugee law, are we talking about international law that is explicit and only about refugees? Or are we talking about international law, international human rights law, for example, that applies refugees as well as other humans? And one of the things that I find as someone who has worked for many years with refugees in a variety of countries to advocate for recognition of and implementation of refugees' human rights, so often these conversations get stuck on the Refugee Convention. And so I think one of the things we'll be talking about today is what does the Refugee Convention do? How do we get to full compliance with it? And then what's left and what are the tools? And to me, one of the key gaps is that in the humanitarian sector, in the development sector, in the displacement response sector, so often we focus only on the Refugee Convention, which, as Jim says, would still leave lots of injustice. But I think if we saw full realization of all of refugees' human rights, we'd still have some accidents of geography, we'd still have some issues to be addressed, but we would be a lot closer if we just took the Refugee Convention on its own. I'll say a little bit more about that later in the panel, but I'll let us go on to some of our other panelists now. Okay. Oh, and sorry, can I just say one thing to correct my bio? So I was the managing editor of Forced Migration Review while the current managing editor, Alice Phillip, was on maternity leave. I'm back there again as associate managing editor, so kind of job sharing with Alice a bit, but I wanted to give her credit as well.
Thanks for that, Emily. Apologies. Jonathan, over to you with the same question around in a world of perfect legality, how much injustice would we have?
Well, thank you, Reese. And I think I am the only non-lawyer here.
Where's I got to add one non-lawyer?
But I think it's difficult to imagine a world of perfect legality and compliance in the current situation because the refugee law has now a diminishing relevance. It was instituted more than 20 years ago or so, and the world has changed since then. Approximately 120 million people are forcibly displaced, and that is an injustice already. They are not supposed to be uprooted from their homes. And so let's assume that, yes, everything is perfect. I would agree injustice will still be there, just as injustice is still in all domestic laws in every country. But I think the issue here is that the definition of refugee, as it was then, need a rethinking as we face what we are facing now in the 21st century. Gender is not part of the 5 grounds under the definition of refugee. Is it something that we should think? Gender-based violence, gender-based persecution. But if we leave the law as it is, that is already not a determining factor. We have seen across the board that there are issues that are surpluses that were not seen when the law was established. You speak also of those who are displaced by climate disasters. They are not technical refugees. And so what is the framework to address that injustice they are facing? So I think injustice will continue despite if the world is, but it is not. There's no perfect. Compliance is not there. States that actually advocate the establishment of the international system are breaking it with impunity. And so we will talk further on what to be done, but I think it is not realistic to see a perfect compliant and legality here. And even if it is, injustice will still.
Thanks, Jonathan. And you mentioned a valid point around when the Refugee Convention was first drafted, enacted, and the grounds for persecution included in the convention. Of course, many states around the world have developed that definition within their own domestic frameworks, and we do see now many states around the world that include more expansive definitions, and their case law has developed to include, for example, gender-based violence, especially through the development of the social group, identifying groups of people that maybe not specifically identified under the Refugee Convention, but given the context that they live in and the experiences that they have, how their social group is affected. And so it may be, for example, a social group is quite wide to include all women, but it may be that women in a particular part of the world, in a particular country, suffering particular violence against, for example, gangs or the like in their context, may be considered a social group under the Refugee Convention, and so are facing persecution as a result of being a woman in a particular part of the world facing particular violence by a group there. So there are ways that the law has been adapted to cover some of these shortcomings, and I know that also in other contexts, like New Zealand, there was a significant case around developing the breadth of how we include impacts of climate change and protect vulnerable people that are displaced as a result. But you're right, there's a lot of space for the law to still grow and protect the most vulnerable.
And those cases are ad hoc. Then the idea is we should.
Well, they're also legally binding. So the UN Human Rights Committee has already ruled on the duty under the Civil and Political Covenant to admit people fleeing climate disaster who face particularly egregious harms. This is not just hot air. It's binding legal obligations, as are the notion of gender or sex as social group. I think we're way past those debates.
Yeah. Thanks for that, Jim. And just to build on that point then, we have these structures, obviously, developing and case law that's building and these arguments that extend the law, which is the beauty and the protection under refugee law that can be developed. And so I wanted to give you an opportunity to respond to that question around the legality of it as well.
Sure. So first, hi, everybody. I'm so delighted to see so many people here. Thank you for making your way all the way up to the 4th floor to be with us. I echo what my fellow panelists have said, you know, as especially those of you who are sort of in law school or becoming sort of refugee or human rights lawyers. We promise we're going to have some positive things to say, but this question really is important and is unfortunately, you know, lends itself to some rather cynical answers. So you've heard a bit, so the definition of refugee within the convention is too narrow. And it's actually historically more narrow than some of the definitions that came before it. So we have this idea that the 1951 convention is sort of the high watermark in terms of international law around refugees. That convention was never supposed to play that role. At the time, you're in post-war Europe, you have essentially what was almost pejoratively called this residual caseload of refugees in Europe. And before that, you had had a few things that had happened. You had had the Marshall Plan come in, so sort of a massive influx of aid on reconstruction within Europe. And you had had a pretty large mass resettlement program. And so resettlement means sort of once a refugee is in a country's asylum, and then they're allowed to sort of seek a kind of more permanent existence in a third country farther afield. So you had had these things going on. And the idea behind the convention was that sort of the Western countries, the richer countries sort of farther afield were a little bit tapped out. And they were sort of like, we feel like we've done what our bit. And so the Refugee Convention was really a kind of third part of these two things. So development aid, massive development aid, and resettlement. And then the convention itself was really supposed to kind of responsibilize the Central European asylum states in Europe to say, now the onus is on you for these residual caseloads, and here's the rights that you need to give them. And at the time, it wasn't actually that big of an ask. We can see this, of course, because the definition of the refugee that was written in 1951 was that you had to be displaced in Europe prior to 1951. So it was a very, very, very Eurocentric document at the time. And that was basically its goal. It had a pretty modest goal. You can see this as well with the creation of UNHCR, the UN Refugee Agency, which was created with a 3-year mandate and a $300,000 budget. And it was essentially supposed to go around to the central states where most of the refugees at the time were, all in Europe, and kind of make sure that they were complying with the convention. And that convention put all of the burdens on them. And this is where sort of the origin of the accident of geography problem happens and then gets exacerbated as soon as the shift away from Europe starts to happen. The other major flaw in the convention is that it presupposes presence for the same reason. It was looking at this residual caseload that was already in sort of countries of asylum. It says nothing about which country do you have a right to seek asylum. It doesn't even give you a right to seek asylum. There is a sort of a right to seek asylum under the Universal Declaration of Human Rights, Article 14. Seek and enjoy asylum, but it's more of like a right for states to grant you asylum if they feel like they want to do that. So there's this huge gap. You have a right to refugee status and then all the rights that come with that, but you don't actually have a right to even get a foot in the door really under the convention. The twist is, of course, non-refoulement, and which is sort of the fancy French word for the right not to be returned to danger, let's say. And so that then creates its own dysfunctions because you don't have a right to enter, but you can't be returned. And so you end up seeing people in a limbo world. So there basically, I think what we're all trying to say is that the Refugee Convention has sort of come to a prominence that it was never designed to have. It has these limitations built into it. Some of them have been addressed through some protocols and sort of widening of the definition, creative lawyering, which got, for instance, gender or non-state violence to sort of count in terms of the persecution criterion. But overall, you have a document that was drafted and enacted in a very, very specific point in time that has shadings of Eurocentrism and some other issues that came of life within the beginning of the Cold War and became very dysfunctional through that, does not have responsibility sharing like we need it to. And I think for me, the most sort of jarring thing is that it doesn't give anybody a right to access asylum procedures in any given country, except maybe if they're the neighboring country.
Thank you to each of the panelists. I know that that was quite a significant question to grapple with, imagining in a world of full compliance. And through that, I want to focus a little bit about humanitarian aspect versus some of the legal arguments that we've been discussing here. So Jim, I'd like to go to you and with a question. Why has international refugee law, in your opinion, become so enmeshed within humanitarian practices and structures as opposed to these legal ones.
Right. And I do want to preface this by saying, perhaps in slight disagreement with my co-panelists, UNHCR, the refugee agency, refers to me as an apologist for the Refugee Convention, and I wear that badge with great honor. There is nothing in my view wrong with the Refugee Convention. The definition makes perfect sense if it's applied properly, and the rights regime works if it were ever to be implemented properly. Missing is the third plank that the drafters intended, burden and responsibility sharing. So I want to really not send you away in despair. This is done properly, it could work, but we need the third plank. As for why, some of you may be wondering why the question comes, this descent into humanitarianism. And some of you are probably thinking, isn't humanitarianism kind of a good thing? And I think the question is really prescient because it makes clear why it's a problem. Catherine d'Auvergne, who's probably one of the most brilliant writers on refugee law, has written this in an article that's about to come out. Humanitarianism is grounded in inequality. It cannot be demanded, but must rather be beseeched. The point is, once you shift into humanitarianism, you move out of a rights-based framework and into a petitioner begging bowl situation. So the question is really an important one. And the truth, I think, is linked to the history that Leo was talking about. Refugee law, international refugee law, is almost exactly 100 years old now. In the early years, 1920s, 30s, 40s, 50s of refugee law, honestly, it was a European convention for European refugees administered largely by European countries. And so they set up rights, which effectively do include a right of entry, in my view, but more importantly, rights to freedom of movement, to educate your kids, to work, to own property, all sorts of extraordinary human rights, some of which don't exist even in general international human rights law, like the right to private property. When this was a bunch of Europeans admitting other Europeans, they didn't have any problem acknowledging those rights. And indeed, if you look contemporarily, the European Union is doing that now for Ukrainians. Ukrainians are given all sorts of rights without any process, when other refugees are given none. That ought to be the signal as to what went wrong here and why we shifted into a humanitarian regime. And the answer is the globalization of the United Nations. It happened in the 60s, which led to a document that Leo referred to, the 1967 Protocol, which theoretically universalized refugee law. You couldn't have the majority of the General Assembly being non-northern states and pretend that only Europeans could be refugees. You had to broaden it. So they did, at least formally. But in substance, it never really happened. There's been a pattern of resistance right from the beginning. So people would say, oh, well, these Africans, are they genuine refugees? Or, well, I'm not sure there's really a right to be admitted, thinking about the brown and black faces who were arriving. The definition was for a period narrowly interpreted as well in ways that it had not been before. Again, because these were non-Northern people arriving. And what I've called the phenomenon of non-entrée, fancy French word for you shall not get in, replaced non-refoulement, we shall not send you away in practice. So what we had was a formal universalism sitting on top of a substantive apartheid. This is where humanitarianism clicks in. What do? We've got this treaty from the 60s that says it's a global refugee regime, but we don't really want these non-white people arriving. So why don't we actually focus on delivering assistance over there, near where they begin? Indeed, said UNHCR, let's focus on internally displaced people. Ideally, they don't even get to leave their country. We'll deliver tents and blankets and do all sorts of things that will keep them there so that we don't actually have to address them as human beings entitled to the asylum that we actually have codified. The saddest part in all of this is not just that states wanted to do this. The UN Refugee Agency, UNHCR, that is supposed to be the guardian of refugee rights under its statute, could read the political tea leaves. And it knew, with only 1.5% of its budget guaranteed every year, that it better do what the 20 rich countries that fund it wanted it to do. So guess what it did in the 1990s? It becomes a humanitarian agency. Most of UNHCR now is focused on the tents and blankets side of delivery, not on the protect. And if you look in their statute, there's not a word about humanitarian assistance. It's all been added on by resolutions, and the protection mandate now is the tail on the proverbial dog. What does UNHCR get? A fancy new building in Geneva when everyone else's budgets are being ripped apart in the 1990s. Its budget goes up, other people's budget goes down. UNHCR knew how to play the funders, and humanitarianism was the key. We do something that you're happy with, doesn't cause people to wash up on your shores, and we still look like we're being universally caring. How convenient is that? So the bottom line is humanitarianism, in my view, was the perfect way for states to mask an agenda of racist exclusion under a very pretty veneer of do-good minimalism. And that state-based agenda was actively embraced by a self-interested UN refugee agency, leaders of which found it very expedient and institutionally rewarding.
Thanks, Jim. And these are the realities that many refugees and refugee-led organizations are calling out now. The realization that the UN agency that is seen as the beacon of hope for many refugees actually operates to the interests of states. And so that realization, when we have a refugee Geneva specific training program, and that moment of, when refugees are taking that training and realize these power dynamics and how it's operating completely differently to perhaps how they had thought the system should operate, is quite a disappointing but important moment to realize then how the system works, and then therefore how do we operate in this context, and what tools do we have at our disposal. And you mentioned very important points around this humanitarian focus. And the other aspect of that is obviously because these questions of forced displacement are deeply political. And so this Band-Aid approach of let's send money, I believe, actually avoids us talking about the real issues, the roots causes of forced displacement, because we have no time to talk about them, as we're often told by senior officials in this global refugee regime. We have to focus on the immediate humanitarian needs. Talking about the root causes is for another time. On that note, I'll go to you, Leah. To what extent do you think this central problem stems from the imbalances that are built into refugee law, as opposed to in addition to or in breach of? And you started talking a lot about the way the system is built. So
so I think you've heard a bit of all of our theories about sort of some of the drawbacks or the shortcomings or the omissions within the Refugee Convention itself. I do share Jim's view that in many ways, though, the 1951 Refugee Convention is a remarkable document. And I tend to think that chapter 4, which is simply called welfare, that's my favorite chapter. It tends to be one that nobody talks about. What it does, first of all, is it gives you a sense that welfare rights are on the table. In an era where, especially now, refugees and migrants are seen either as sort of charitable burdens or as sort of exploitative workers, that this is a chapter that was trying to get out of that problem, that refugees were, and today most refugees are women and children, and children especially should be in school and not working, right? So rights to education, rights to public welfare, rights to, sort of social housing. But that presupposes a kind of welfare state. And so the other issue that's going on at the time, of course, is that you have the Marshall Plan, you have basically the rebuilding, the reconstruction of Europe, including its welfare state. And what happened was the Refugee Convention actually worked extremely well in some senses. You had this residual caseload. The whole point of it, that sort of UNHCR's first purpose, was clearing out the camps, getting people out of camps and into sort of integration style situations. You have the exact opposite of that in most cases, and that started once the focus shifted from Europe to the rest of the world, and you start to see it immediately. So originally UNHCR was not just not funded, but it was actually literally banned from doing direct assistance, so humanitarian aid. It was banned from actually handing out camps and tents and doing these kinds of things. That it is now predominantly funded, and that is what sort of the bulk of the organization does today. That was not what it was supposed to do. It was supposed to, again, enforce compliance with these set of rights, including these welfare rights, in order to allow refugees to integrate into a system for all the reasons that we know that welfare states work and that are important. The politics then changed. So James mentioned this sort of humanitarianization problem. This is a huge problem. You basically have a kind of two-tiered system being created by the 1950s, 1960s. European refugees, and increasingly refugees fleeing the Soviet Union, who would not have actually met the definition, because the definition originally was prior to 1951. But even before the 1967 protocol, were basically being treated as convention refugees because they were Europeans fleeing communism. They had immense political value in the West. They were basically symbols of the barbarism of the Soviet Union. And so the West, of course, was not going to turn them back. You also had what the scholars call this exilic bias. So a bias against forced return, which is how non-refoulement became such a fundamental principle, because the West figured we're not going to send people back because politically this is actually advantageous for us to take these folks in. There was a huge race element to this. Of course, most people were fleeing Russia, or were sort of culturally white. Until the 1980, the U.S. definition of refugee was someone fleeing communism. So this is not something that sort of stayed in the 40s, 50s, 60s. But the other thing that's going on, of course, is that UNHCR and the humanitarian regime is now emerging, and it's shifting focus to the global south. And as soon as that starts to happen, the Refugee Convention kind of goes out the window. There's no welfare rights. Well, there's no welfare state to have rights. It was one of the arguments. So encampment became the norm, humanitarian aid became the norm, and there was this sort of double standard around geographically. If you were fleeing some kinds of conflicts, you were going to be put in camps, or you were going to be essentially contained, versus if you were fleeing sort of a communist conflagration, you were going to be welcomed. And that double standard in some ways persists with Ukraine. You see the difference between Europe's embrace of Ukrainian refugees versus how it treated the so-called refugee crisis in 2015, 2016, and beyond. So this is definitely still a problem. It's a problem that's embedded in kind of the politics of this. And then the other piece I'll put on the table, not to overcomplicate things, is that I mentioned the Marshall Plan. So the humanitarian sector has a big responsibility here, but so does the development side of the house, the sort of the big money, the World Bank, the IMF, the sort of bilateral development aid. And what they were doing at the same time was not giving Marshall Plans to any of the rest of the world, but instead implementing a kind of extractive neocolonial economic system, which was making it harder for these host states that were actually then the main host states to do right by their own citizens. And so then the added burden of having refugees there created political dysfunctions, which led to encampment policies, which led to sort of the dysfunctions that we see today. Before that, you had moments of complete solidarity. Tanzania is an example, which was an incredibly welcoming country. You had a president, a sort of post-colonial president, who saw refugees as part of the citizenry, education, total access, basically what the convention was saying. And then you had development conditions and development people saying, no, you can't afford that, and you have to, open up your economy to foreign investment, and now you're in a debt trap, and all the rest of it. So there was definitely a shift from the kind of post-war moment to when the universalization of the refugee definition happened, but it didn't happen in the same way. It didn't simply universalize the system that Europeans had started in Europe.
Thanks. And I also agree with what Jim and Leah you've also said that the problem is not the Refugee Convention and the way that it's drafted. If read carefully, it provides a good definition and the way that it can be used, and we've seen it used to protect refugees, provides really good protection when used appropriately. And actually thinking about all these political contexts and where we are, and Jonathan, you mentioned in light of what's going on in the world right now, the reality is that if we opened up that Refugee Convention today and tried to create a document that we thought would be strengthened and better protect refugees, I think the consensus, at least among lawyers and our communities, are that we would lose probably most of the rights enshrined in that document and end up with a much weaker system and less protection for refugees. So opening up that can of worms is quite scary for us in terms of if we want to debate what protections should and aren't included, we have to think about what we have now and what we could lose. And Jonathan, going over to you, what changes in our understanding, if we're talking about this refugee regime, if we are not seeing it as broken, but actually if we view it as well functioning to the benefit of powerful interests?
I think if we have that mindset that there's nothing wrong with the system, nothing will change. And it will remain with the problems we are talking about. And so we have to come to the reality that the system is broken. It's just like when your house was built in 1930s, you need renovation. In a house, you are not just abolish it. You renovate it so that it serves the purpose. That's the same thing here. So the mindset has to change to accept the reality that the system is broken, and then focus on what really need to be fixed instead of seeing it as a well-functioning system. Of course, that's what the powerful states that institute this like everyone to see, that it is well-functioning because it serves the interests of the powerful states. But for those whom the system was designed to serve, that is not the perspective. I have been on the receiving end. I lived as a refugee for 13 years in the camp. And so what we're talking about here is not abstract. To me, there is the human element that is practically seen there by the people. And the people that have lived in the camps for decades are asking the question whether the world has abandoned them. Their generation, you talk about the protracted situations, people that have 3 generations born in the camps. Is there such as a system that protects refugees? That's the question. Because what we discuss here in New York is not making sense in the camp, regardless of the lexicon we're using. And so I think the mindset needs to shift. And it's need to shift to the 21st century post-displacement, which is increasingly become protracted, more complex, and it's long-lasting. It is more permanent. And I think when we accept the reality, then we think of how to address those. And so in the current system, and I do believe it's broken, the regime which is constitute of the legal instrument, we talk of the Geneva Convention, the protocol, and then the regional convention like the OAU that has the refugee definition, including colonialism as one of the evils in the definition that you should consider. So regional Latin America has it, and those instruments. That is one part of the regime. And then you have the institutions that are supposed to monitor. We have the UN Refugee Agency, UNHCR, with again, the diminishing relevance, the mandate that originally was instituted has now expanded. And in the countries where UNHCR is operating, it's actually doing the service of the state government in those. And then the people it was designed to serve are actually and as a suppression of those states. It's because its mandate, it has to walk a fine line. In order to be funded, it has to also serve the purpose of those states. But again, you see what's wrong with that. And then part of the regime too is that the norms, there are those principles of non-refoulement. You cannot return a refugee to where it will face harm. But we have seen that what is going on now. And then you have the obligation of the states that they should be abide by this in order to make this happen. So that's the regime in layman's language. But in a state of responsibility sharing, there is a responsibility shifting. These powerful states are shifting responsibilities to less powerful states or host countries, and those host countries are lacking the resources. Uganda, for example, is the largest host country in Africa, and Kenya, of course, where I live for almost 10 years, has an encampment policy. And it argues that if the international community is not sharing responsibility, how do you expect us to serve refugees in addition to our citizens that are also in a country that's has resource thin and it's not having enough? So they have their strong argument too. Is the other part of the way of listening. So responsibility shifting is one indication of what is wrong with the system. So let me organize my thought around 5 current trends here in answering to this question. One, the growing proportion of refugees being hosted in non-signatory states. Countries like Bangladesh, Lebanon, Jordan, Turkey, they are not signatories to the 1951 convention, but yet they are taking responsibility. Well, what do you expect of those countries in their good human hearts? They are serving humanity. But then they think they are not abide by the system. So there will be exploitation along the way, and then refugees will suffer and no accountability. But they are doing their best. And I think it's a credit, but again, a growing proportion of refugees in those non-signatory states. Second, respect for refugee law is in decline among those who have signed the convention. So that is something wrong with the system too. Why don't they get accountability? When countries close the borders to those that should be really admitted based on their well-founded fear of persecution, when refugees camps are being attacked, that is something wrong. Countries now talking about temporary protected status, in EU, in other countries, is because they don't want to make this something their responsibility. So they just give them, well, this situation is no longer temporary, and so we should address that side. And so there is something wrong with that. Even those who have signed the convention, they are the one actually breaking it with impunity. Third, as a result, the displaced people are actually losing confidence in the refugee regime itself. Because if they are still suffering under the law that protect them, then they don't see the need of going through that system. And part of what we know now in the 21st century is that migration is mixed. There are those who are forced, and there are those who are also forced by disaster. Those forced by conflict are going through the same route. That makes migration even a different instrument to address them. But because the refugees, the displaced people are not trusting the system anymore, they are resorting to dangerous ways of coping. And I think that is not healthy for the system itself. And then number 4, the institutional role of UNHCR is being compromised, whether by the states or by their not doing what they are supposed to do. Of course, they have expanded their mandate to IDP, the internally displaced people, because the IDPs don't have a binding framework, at least in my layman's understanding, because they are in their own countries, but the government they are under the protection of is actually the one mistreating them. And so UNHCR see that part of the mandate, but their primary mandate is the refugees. And so that role being compromised is actually not translating well to the refugees in the camps. You know, they can't go hungry for days without food ration because everything is cut and the budget is not there. So again, we are talking about this thing, but they translate into real, real tangible things on the ground. And finally, the fact that you know, impunity is abounds. This is where I think when we look at what needs to be done, is we have to institute or talk about strong accountability mechanism and enforcement. Because, okay, if the law is in the book and it's not being implemented, why is it not being implemented? Okay, who are breaking them? And how should that be addressed in order to bring back the purpose which it was instituted, and that is to protect the powerless we are talking about. The mindset needs to shift from also viewing these displaced people as people with no dignity. I think that needs to shift. That these are not just aid recipients. There are people that happen to have been displaced because their government is not protecting them, but they have human agency. And I think when we talk of the positive trend, it's that the meaningful inclusion of these voices in the discussion, so that the new perspectives see, not the traditional or top-down way. These people being protected by the law has to speak up. And I think that is something that is needed.
Thanks, Jonathan. And you've identified a number of problems or challenges within the current system, notably the lack of enforcement mechanisms. And I think many people may be surprised by the fact that when UNHCR was being designed, there were different camps of how UNHCR should be designed and what kind of power of enforcement it would have over states. And it obviously, you know, there were different camps, one led by, I believe, Pakistan, India, and some like-minded states who believed UNHCR should have a strong supervisory mechanism within its functions to be able to identify breaches by states and do something about that. Whereas there were another group of states led by the US and its allies that believed it shouldn't have a strong enforcement or supervisory embedded structure within it, and that it should be largely left to states to decide how it operates. So I think it's clear who won that argument and the way that UNHCR is designed today. But it was intentionally created that way to not have the power or the teeth to enforce states to do, you know, to behave a certain way within the global refugee regime. So we've identified lots of challenges and existing problems, including the protracted situations and the reality that most refugees will never be resettled. And this has been something that is a key theme within the global refugee regime. When my family was resettled, we were part of a 1%, and today I believe that percentage is 0.0, 1 or 2%. So tiny fraction of people that will ever be resettled. And so within all these challenges that we've identified, Emily, I'm going to go to you for this tough question of what are the solutions in the face of powerful interests that may not necessarily align with the interests of refugees? How do we use refugee law or the law at our disposal in the service of people experiencing forced displacement? So easy one for you.
Thanks. All right, so, you know, we're going to walk out of here and it's all going to be solved, right? Unfortunately not, but, you know, I think that I really want to start conversation about solutions by speaking to Jim's point of, you know, if this is done properly, if the refugee convention is used in the way that it is used in the way that it was perhaps originally intended as, and is interpreted in a way that that should be from a kind of legal standpoint, then yes, the Refugee Convention can do really a lot. But I think this is where we get into the critical legal theory and law and society critiques that unfortunately the system will always serve the interests of the powerful. And we've heard a little bit about, about how that's played out with UNHCR and the supervision of the Refugee Convention, the way in which the Refugee Convention is being interpreted, being, I think, in practice used by states such as the US to limit and exclude rather than to include. Now, I'm not an Audre Lorde absolutist, so she said the master's tools will never dismantle the master's house. But I think if you can steal the master's sledgehammer, you can still smash the window, at least until the master gets, smash-proof glass put in. So I think there are ways that we can use the laws that exist to advocate for the rights of people with less power, and to be effective in redressing that power imbalance to a degree. I think the problem is, and this is kind of how I look at it, the problem is that the longer we use a particular tool, the more that the forces against us mobilize. So if we're advocates for kind of the powerless or the folks with less power, I think we have to be nimble. We have to change our tactics, and we have to recognize that just because something looks good on paper doesn't mean that it will always be the right tool dismantle the power differentials and the results of that, the injustice that results from that. And so I think, really there are two tactics that I would like to see us using as international lawyers who care about refugees' human rights. One of them is the economic covenant. So I ran asylum access for about 17 years, almost 20 years. And I was in a lot of meetings with states that host large numbers of refugees, and with staff at the UN Refugee Agency, at UNHCR, staff from other NGOs. And the governments would so often say, no obligations when it comes to refugees working, for example. So I'll use work as an example because that's a right that I know a lot about. We have no obligations when it comes to letting refugees work, or letting them work formally so that we can enforce labor protections. We have no obligations. And particularly where these countries were non-signatory states, particularly where those countries had made reservations to Article 17 of the Refugee Convention, UN staff members, the NGO staff members would nod and say, you're right, you don't have any obligations. You don't have to do this legally, but it would be really nice if you did. And actually, many of these states have signed on to the economic covenant, the International Covenant on Economic, Social, and Cultural Rights. And so these states do have obligations. And in fact, under the current interpretations, Jim, you and I can argue the technicalities of this, but under the current interpretations, the general comments that have come out over the last decade from the Committee on Economic, Social, and Cultural Rights that is responsible for interpreting the economic covenant, I think it's pretty clear that refugees have an immediate right to work, which is actually stronger than what you see in the Refugee Convention, and an immediate right to work equal with nationals. There's certainly an argument to be made. And yet we see almost no one working in displacement response who's significantly aware of the economic covenant and the rights that it provides. We certainly don't see investment in litigation in national courts, in regional courts, complaints to the Committee on Economic, Social, and Cultural Rights, which is empowered certain states to take complaints from individuals. We don't see a ton of advocacy around general comments. And when those general comments do come out, we don't see then that coming back into litigation in national and regional courts where we could say, okay, now that the covenant has been interpreted in this way, to provide these rights, let's make these rights a reality, let's hold states accountable. So I think the economic covenant is a deeply underutilized tool. And I think we all should be looking at ways we can use that, looking at ways we can advocate for aid to go to strategic litigation in that regard. And I think if we did that, we would see that we would be pivoting to a new tool that could actually have some teeth before the interests against us get there. The second solution that I think is really important is that when we look at the economic covenant, there's a committee responsible for interpreting this. There's a complaints mechanism. There are all these mechanisms that give it some degree of teeth. And when we look at the Refugee Convention, of course, that's not there. But I think there's no reason we couldn't build that. And I think the part of the reason we haven't built that is because the executive committee of UNHCR, so the UNHCR is responsible in theory for supervising the convention. The executive committee of UNHCR is made entirely of states, right? That's because the UN system is set up so that states are the ultimate kind of entities. But states don't represent refugees, right? Their home state couldn't even protect them from persecution or violence, right? So their home state is not in a position to advocate. Their host state has a, will make the argument that they're actually more responsible for their own nationals, for the host country nationals, than they are for representing refugees' interests. And certainly in practice, host states are not representing refugees' interests on the executive committee. And so you're effectively leaving a group of people totally unrepresented in what is supposed to be, in theory, the somewhat democratic system, right? And I think refugees are unique maybe in that way, in that there are arguments for almost any other population that their national government is kind of their representative, but refugees don't have a national government. And so I think there is a model we could look to in the UN system, the International Labor Organization. Because the executive committee, the governing committees of the International Labor Organization are not comprised solely of states. The governance of the International Labor Organization is half states, and the other half is divided evenly between employers and workers, right? And so if we take that logic and we say, look, we need to recognize that refugees are not represented by states, and therefore refugees should have representation. The governance of the agency that is supposed to support and protect refugees. I think that's an easy case to make. And I think we could argue that really the division should be 50% refugees, maybe the other 50% divided between host states and donor states, the states that are putting in the money and the states that are housing the vast majority of refugees. I think that's an easy case to make. I think we have a precedent for it. Of course, there's the political will question. That's a challenge. But I do see that as displaced people have been mobilizing and saying we need a voice at the table, I think this is one of the next steps. And I'll add finally that the World Bank right now, and the World Bank, obviously has a challenging history when it comes to human rights and well-being. But one of the interesting things they're doing is they're working to assess cost of including refugees in national welfare systems, right? And by welfare, I mean that broadly: education systems, disability systems, health systems, as well as welfare for folks who are not employed for other reasons. They're looking at the cost of inclusion in those systems versus what we've got now, which is people in internment camps for decades or generations, and then having to foot the bill for meeting kind of the very basic needs that give them no agency in their lives. Because integrating in a national system, being able to make choices about how you live, being able to work, being able to go to school, that seems like kind of an obviously better solution. And as it turns out, at least the preliminary information is showing that it's much, much less expensive. And so I think there's some really interesting arguments that could be made that could generate some of the political will for some of these bigger shifts that are needed if we are to get to compliance, and if we are to get to beyond that to justice. And so I think those are some interesting paths for us to take forward that get concrete and that we can actually start about now.
You'd like to add to the question around solutions and what we could be doing to?
Yes, I would agree with the ILO governing system as a model, because I think it is time to think the paradigm has been in place, and that bringing the new perspectives into the EXCOM UNHCR is important. Of course, you start change by small step. It would be incremental. And I think one of the positive trends for our young audience and others here is that, you see we are painting a bleak future, but, we are defining a problem so that you can and us come with solutions. One of the positive trends in recent years has been that the inclusion of refugees in the global forum. That is through the Global Refugee Forum, resulting from the Global Compact on Refugees. It's not a perfect thing, it's non-binding. And, but I think the positive aspect is that the voice are coming with some changes that need to be made in the international system. I think that trend needs to continue. One of the things, as I mentioned earlier, is shifting the mindset. Because if you want to talk about addressing the problem, you need to define it. And I think if we think things are okay, then they will not be addressed. And one of the ways shifting the mindset is just recognizing that these are the problems existing, and then start talking about them. I think revisiting the UN Charter is also another step that we can see. Changing somewhere there, because people that don't want to see the change always see loopholes, rely on. There are loopholes in the UN Charter. And I think I will leave it to the legal expert to explore that. But I think the UN Charter is outdated. Let's agree on that and then revisit. I don't come to the idea of opening this can of worms where if we reinstitute a new system, it will not be as what it is. But I think improving upon it, I think not dismantling what we have. And improving upon it include that you revisit the whole charter. How many countries were independent when it was established? And how many countries now are independent, state 193 or more? And it's things like that, common sense, things like that. And then finally, on the issue of solution is that when I talk of the definition of refugee, I agree with its narrowness, that it was narrow on purpose to focus on this particular category. But the reality of the 21st century is now, and that's the loophole being used by SAID, is that they categorize everything as migration. There are categories of migration, forced and voluntary. And then you have climate, and some legal experts even incorrectly call climate migrants as refugees. Technically, they are not. So if they are not, and they are suffering some harm, well, you talk about then their framework under the international system. If you don't want to include them in the refugee framework, dialogue is a way to address issues. Running away from it is just not accepting the reality.
I don't really want to be the legal realist on this panel, but I'm going to play the role because I love the creativity that I'm hearing. But I think we also have to be honest about this, and this will lead in the Rez's last question about for whom is this regime, for whom is it meant to work? It's not meant to work for refugees. Anybody who thinks it is dreaming. It was always a management tool created by states to manage a perceived threat. That's what it is. Whether you call it international human rights law or refugee law makes no difference. Both of them do the same thing. So, could we change the executive committee of UNHCR? Well, at one level, I say, who cares? It doesn't have much power anyway. But the bottom line is, with all due respect, I think the chances of getting 50% refugee seats on a body now run by states is 0. Unless you neuter it and basically make it just a talk shop, in which case states would be happy with it. There has been a proposal on the table for 25 years, a comprehensive model on the table for 25 years for how to fix the global refugee regime in a way that would resolve all of the problems we've spoken about. Devised by half a dozen governments, 100 experts over 5 years, and it has not happened because of what Emily rightly says, the overarching problem. We can't dismiss it, a lack of political will. Why? Because there is no desire to fix the problem on the part of power brokers. And I'm sorry to say that, but I believe that's the truth.
I'm very sorry to only add to that because I just want to bring up one point that I don't know that's been mentioned, but the governments that we're talking about, so we're predominantly talking about Western governments as funders and as sort of shirkers of responsibility. We've got an accident of geography problem where most refugees in the world are in global South countries, usually neighboring their own. But for instance, Lebanon, which is obviously going through its own issues at the moment and has been, but 1 in 4 people in Lebanon is a refugee. If we were to get anywhere near that in this country, it would be about 85 million people flowing into this country overnight, except this country has lots of space and it's not, our population density is way lower. So this is absolutely a political geography problem. But the other issue is that the rich states are not simply underfunding or sort of shirking. It's that their own foreign policies are actively contributing to the displacement that is driving this whole problem. And I see a lot of nodding heads, so I don't actually think I need to say too much more about that. But I'll give you 2 examples, perhaps. The war on terror. War on terror displaced, the Brown University has a cost of war program, and they have a very, very conservative estimate, which I think is from years ago, that simply the US war on terror displaced about 40 million people. And that's very, very conservative. So you've got that problem. You have US and Western support for sort of draconian austerity debt deals with the IMF. Emily mentioned the World Bank, and I'm very excited actually to learn more about the World Bank doing this, but the World Bank does some other stuff, right? So you've got sort of neoliberal, kind of neo-colonial economic policies that are being foisted on the countries that are hosting refugees, that are increasing poverty, which then create political conflicts between citizens and refugees. And the government is actually locked in this bind, and I feel for them, which is basically, we've got these big international institutions telling us we have to slash our budgets, we have to give up all of our land to foreign investors because trickle-down economics works, apparently. And then you've got the sort of the UN and the humanitarian sector saying, but please include refugees in all of your schools. And it's like, we can't include our own kids in our schools. And so that's and so the geography, the sort of accident of geography problem is sort of being hyper sort of intensified by the fact that these countries are debt ridden, that they've had economic models foisted on them for decades. And those are just the decades after colonialism, where they can't build the welfare states that the Refugee Convention requires. They can't give the services that that international economic human rights law requires of their own citizens. And so when the international community comes and says, oh, but please include refugees in your schools, in your social sectors, in your healthcare systems, meanwhile, the rich countries of the world are both underfunding those programs and refusing, doing non-entree, doing refoulement, saying, over there, not here. You have, of course, a political problem, which is that, and it's roughly 10, 11 countries that host most of the world's refugees, and they're fed up. And they're fed up for right reasons. And of course, the last thing we want is them shutting down the camps and sending people back. But we have to, especially as the global north, recognize that this is a problem that we've created. This is a problem that our foreign policies are exacerbating. We are underfunding these same countries. We're asking them too much, especially given what little we're contributing to the situation and what we're contributing to it. And so, even in the US, the Biden-Harris administration has a very nice, if you read it, it's a strategy to address root causes. And it sounds very nice. And not a single word of it has anything to do with what the US has been doing in Central and Latin America for centuries, right? And is continuing to do. And, like Honduras, for instance, is a good example where the US was doing some shady stuff and then supported this coup that's led to the kind of democratic backslide in Honduras, which is just getting back up on its feet. And you still have the State Department being mad because the new government wants to have a progressive economic agenda and not simply cater to US companies. So these are also the dynamics that we have to address. Now, in theory, especially those of you who are US citizens, maybe the pressure, this is an easier solution. US has much more control over its own foreign policies than it does over what Lebanon or Honduras do, right, in theory. And so maybe that's where the focus has to be. But it has to be part of the conversation, because it's not simply that the West is being sort of bad, charitable, or sort of bystanding or shirkers. They are, and that's a huge part of the problem. But they're also actively contributing through bad foreign policies to the root causes. And then they have root cause strategies. And as you can tell, I'm very frustrated by this. But I just, yeah. Anyway, I just wanted to end on that happy note.
Want to add something?
Yeah, I just wanted to kind of respond briefly. And I mean, you're not wrong about any of this. And if you, for those of you who are kind of early in your legal careers, if what you're motivated to do is dive in and try and prove US foreign policy, like, let's do it. That's great. I do want to say that we have to be a little careful about some of the rhetoric around countries not having money, around countries not being able to absorb numbers. I mean, so if you talk to the government of Bangladesh, they will say 44% of our population in Cox's Bazar is refugees. Like, we just can't handle it. But if you run the numbers, if you distributed people evenly, and I'm not advocating for forcibly moving refugees, around Bangladesh, but if you provided incentives and let people distribute themselves evenly around Bangladesh, and they were evenly distributed, you would end up with less than 1% of any community being refugees. That is not overwhelming. This is not a numbers problem. The vast majority of countries, Lebanon, I think, being one of the smaller exceptions. And similarly, yeah, you're right that the US and other kind of donor nations, as they're sometimes called, has been underfunding. That's where, when you look at the numbers for integrating refugees into your systems, you could spend, you could take that money and you could pay for integration, and almost certainly you would have money left over, right? You could pay to build hospitals and put doctors in an area that's underserved, serving refugees and locals, and you would spend a fraction of what you're spending to put these in refugee camps and staff them with lawyers who come from the global north. I know we probably need to end. And can I just say one thing on the political will question more generally, Jim, is, how do we create political will? We make the powerful uncomfortable, and then we provide a pathway for them to become comfortable, right? And that's where I think, yes, we certainly have some gaps in political will, but the refugee leadership we've already seen going on, the refugees demanding a seat at the table, that our seat, Rez's organization, and organizations that John has been part of, and many others, that is confronting UNHCR. That is making them uncomfortable because it's confronting them with their hypocrisy. And I think we can build on that. And I don't think it's entirely unrealistic to say that EXCOM, the executive committee of UNHCR, could eventually have refugees. Maybe not 50%. That's the opening negotiation, and then you see what you get to. But I think we would see that, and I don't think UNHCR's executive committee would be as useless a body if it actually had refugees on it. I mean, yeah, it's pretty useless now, but that's by design. And similarly, if we use the instruments we have to sue, then we do make governments uncomfortable. We use the instruments we have to sue and publicize and shame them. We do make governments uncomfortable. And the way they can become comfortable is by getting in compliance. So, it's not perfect. I mean, you're right that probably if we do all of this and we spend all of our time on it, we're, maybe gonna reduce injustice by, some 10%, right? And we're still gonna have 90% that's sitting there. But I think we can do something, and I think we can make a difference, and that will impact people's lives.
Just a really quick footnote. I'm gonna actually agree with Emily now. It does happen.
Mark my calendar.
She totally can. You wouldn't know that we've worked together for 20 odd years, but it's a healthy sparring. Well, bottom line is, the model that I told you about that's been sitting on the table to fix the refugee regime, the 20 billion US dollars that rich countries spend every year to assess the claims of the less than 20% who get here would be more than enough, said the economists in our study, to fund the burden and responsibility sharing model that would eliminate all of the problems we're talking about. So there is an easy way to get to yes with not one additional euro, dollar required. So I think we do need to be optimistic about this. And this is where I agree with Emily. What we've got to become better at is confronting the lack of political will and finding ways, perhaps by making them uncomfortable, but I would say also by offering a rational voice that doesn't simply beg for more and more and more and more entry, but rather takes state interests seriously and explains how they can legitimately be met without undermining refugee rights. We've got to make that dialogue happen in ways that I fear as academics and advocates, we've not been as good at as we should have been.
Thank you. I don't think, does the audience allow 30 seconds? There we go.
If the system was designed to protect the refugees and the system is not protecting them, then it's something to think about, because it should not be the self-interest of the state that override the interest of the refugee. And finally, I have to agree with Leah in terms of the root causes. If we want to address all these issues, let's solve the problem at its root. And I think that should give you food for thoughts in your legal career.
Often when I'm joining a panel that's touching on refugee law or humanitarian issues within the global refugee regime, I'm told, don't get political. So I'm glad we've done exactly the opposite of that, because it is a deeply political problem. And as everyone on this panel has said, most of these issues can be addressed through political will. And I heard a phrase all of last week where I attended the XCOM in Geneva about mediocre leadership all around the world. So I challenge you all to join us in ensuring that we get over these mediocre leaders all around the world, that we challenge the foreign policy that exists, and that we know that there is more that we could do if actually we just do it. That's how simple it is. So thank you so much for joining this panel today. I hope that
Raz in our seat who organized this all.
Absolutely.
thank you.
Oh, nice to meet you. Yeah.
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 So, wish we had fantastic.
Too. I was just saying, I wasn't, expecting that. That's-
No, I know. I looked and I was like, oh, then we can have a, hey.
Okay.
Like that.